All right, here with Kevin Schofield, SCC Big news today out of the federal court. The case of around surrounding the CHOP, where business owners and residents of Capitol Hill suing the city of Seattle. The federal court made some preliminary rulings. Tell us all about it.
Yeah, so this is the case where some business and residents who lived in and around the CHOP, like you said, were suing the city because of damage to their property, unable to get into their business or their homes, in some cases, some injuries that they sustained while the CHOP was going on. Now they're suing the city over this, and they also want to try to make this a class action suit to get, so that everybody in that whole area who is affected by the CHOP could be a part of this without them having to go around and sign up every single individual for that. Now, it's super early days in this case. It's still super early days. They haven't done discovery yet. Discovery is this process where both sides have to give the other side all the evidence and emails and documents and everything they have, related to this. That hasn't happened yet, so it's super early days still. But the city filed a motion to try to get the judge to dismiss this case. And if he won't dismiss it, at least say, well, it's not a class action lawsuit, right? So those are the two big issues that they've been, arguing back and forth for about a month on this. And as far as the class action suit, in order to get a class certified of plaintiffs or something like this, you have to show that basically they've all suffered basically the same injury, the same facts and legal issues apply to all of them, and they're all asking for basically the same remedies, right? So that there's an advantage to doing it for all of them. There's enough of them that you don't want to have separate lawsuits for all of them, and it's and the judge it's efficient for the court to do it all as one. And the city said no. They're like, some of them have injuries, some of them are have businesses they couldn't get. They got a bunch of different kinds of issues here, so they're not a class. And the judge said, well, it's too early for me to decide that. I want to let them do discovery. Let them sort of get all the facts out there, and they may come up with, proof that it's all the same facts and legal issues and arms and all that. So too early. So he said, I'm not going to do anything with that yet. So then when the city said, their other thing they raised in their motions, which is just like dismiss this, they said, basically there's nothing in this lawsuit that you can sue the city over. And the reasoning for that is the law says that you can't, that the city isn't required to protect you from every bad thing that could ever happen to you in the city, right? So if particularly things that other private parties, private citizens do. So if somebody tries to rob your house, for example, you can't sue the city over that unless you can show that the city was an active supporter of that bad thing that happened to you, right? So if, somebody tried to rob your house and the city let them into your house, then you can sue the city over it. And in this case, they say what the plaintiffs have said is that that the city was an active supporter of CHOP. They said, hey, look, they gave them barricades to block off the streets. They gave them a medical tent. They gave them a bunch of medical supplies. And the police department and the fire department had stated no response policies to the CHOP area. They weren't going to go in there if they got 911 calls on it, right? So for all those reasons, it looks like the city is really an active supporter of this, and therefore it's okay to sue the city. And the judge said, yeah, that's plausible. Yeah, it's early days, and the city may come up with better reasoning and better facts to show that they really weren't an active supporter. But for this really early point in this case, that is entirely a plausible and reasonable thing for the plaintiffs to be saying. So no, I'm not going to dismiss this case. It goes on. There was one particular issue he did side with the city on. One of the many claims that most of the claims are around property rights, but one of the claims that the plaintiffs argued for was called equal protection. We all have equal protection under the law. You and I and everybody else, the law applies the same to all of us. We can all sort of get our grievances addressed the same way, right? But what the plaintiff said was that because the police and the fire department wouldn't respond to 911 calls, that they didn't have equal protection under the laws. And they said that because the people participating in the CHOP, weren't being actively, policed all the time for all the bad things that were happening there, that they were getting special treatment. And what the judge came back and said on that was, well, if you're going to argue equal protection, you have to basically do an apples to apples comparison, right? And in this case, in order to prove that there wasn't equal protection in the law, there would have to be something like basically exactly like the CHOP somewhere else in Seattle that the city treated differently than they treated the one on Capitol Hill. And since there wasn't any other one, it's one unique thing, there's no apples to apples comparison. So he said, okay, on that one, I buy the city's argument. You don't get to argue equal protection, but all the property rights stuff, the damages, all that other stuff, it's sure, at this point, it's plausible that the city is actually liable. And if that's true, if the city really is found to be liable from, that's millions of dollars of damages that the city could be on the hook for.
Yeah. And believe me, the Converge footage is like in so many of these laws. It's all over the place. So one question here: what's next? Where's the next hearing, or how's
so the next thing is discovery. Well, assuming the city doesn't decide to appeal this right away, and they might decide if they really want this to go to appeal it right away. I checked with the city attorney's office this afternoon. They're like, we're still reading and analyzing it. We haven't made any decisions yet. They'd only had a few hours at that point. If they decide not to appeal, then it goes on to discovery. And that means that, both sides, like I said, are going to have to give up their documents and their emails and any other evidence, photographs, any other evidence they have of what happened, right? They get to make a list for each other. Like, here's all the stuff that I want, and they have to give it to each other. And that's going to happen. And then there may be another round of motions after that of, asking for, rather than go all the way to trial, say, let's just decide this now based upon, the evidence, what they call a motion for summary judgment on this. And to get it decided, before it gets a trial, there can't be any issues about the relevant facts. And it just has to be an issue about how the law applies to it. And then the judge can say, okay, here's how the law applies, and decide it. If there are issues about the facts, that's why you have a trial, right? So a jury can sit down and see the evidence presented by both sides and make a determination about what the facts are. But if the facts aren't an issue, then this could get decided really quickly. So we'll just have to see what they come up with.
All right, Kevin Schofield, SCCinsight.com. Thank you.
Thank you.